Hi, I'm Darren Lau.
Hi, I am Alexandra Wong.
Hello guys, my name is Christopher Charles Msanyika. I'm a law student from Taylor's University, semester 1. In order to advise Domio of the potential claims against Dr. Richard Maverick and Dr. Newton James, based on the case of Donnelly and Stevenson of 1932, we need to look into three factors of negligence, which are duty of care, breach of duty, and causation. First off, for the duty of care, we need to establish whether there is duty of care between Dr. Richard and Domio under both the law of England and Wales and law of Malaysia. According to the case of Pippin and Shepherd of 1822, the standard of duty of care between doctors and their patients has been established. Hence, there is duty of care between Dr. Richard and Domio. Next, we have to determine whether Dr. Richard has breached duty of care to Domio under English law, which is by applying Montgomery Test. This test originated from the case of Montgomery and Lanarkshire Health Board of 2015, where a diabetic pregnant woman was not informed of the risk of shoulder dystocia, who said she would have had a Caesarian instead. It has held that the defendant should have been informed about the risk of shoulder dystocia, which was 9% or 10%. She had the right to know the risk that she might face before the surgery. Nevertheless, the Montgomery test for consent with a test where the materiality of risk involved had to be assessed by reference. Not a responsible body or medical opinion, but a reference to a reasonable person in the patient's position. Doctors, as a result, are now obliged to ensure reasonable care and to ensure that the patient is aware of material risk involved in any recommended treatment and of any reasonable alternative or variant treatment. However, under Malaysian law, we will apply the test in the case of Rogers and Whittaker of 1993 under the High Court of Appeal. In this case, the defendant was not informed about the risk of sympathetic ophthalmia before the surgery. She argued that if she was warned about the risk, she would have not had the surgery. The court held that the defendant was liable, as the claimant had the rights to know about the risk of the surgery. The courts adjudicated on what is the appropriate standard of care after giving way to the paramount consideration that a person is entitled to make his own decision about his life. In the case of Kamal, Rahman and Oz and Western Plantation Agents of 1996, here the court found both defendants were liable for the failure to provide the efficient ambulance service at the material time, for failure to admit the plaintiff into the hospital. In this situation, there is no difference if we compare both law systems, which are law of England and Wales and law of Malaysia. Undoubtedly, the statement mentioned that Dr. Richard had failed to inform Domio about the risk that he would face through the surgery, which might be the reason that caused him to suffer from a pulmonary embolism. Domio had the right to know about the risk and could make his own decisions for himself. By applying both Montgomery test and the test under Rogers and Whittaker, based on the material risk given by a doctor, if a reasonable patient would have made the informed choice, Dr. Richard could be liable. So Dr. Richard could be liable as it was his duty to inform Domio about the risk of the surgery, and he had failed to advise him about the risk. Furthermore, we need to establish whether there is any causation between Dr. Richard and Domio under English law. For determining causation, in fact, Barfoot test should be applied. Barfoot test was originated from the case of Koch and Kirby McLean Limited of 1952, and where Lord Denham said that if this damage would have not happened but for a particular fault, then that fault is the cause of the damage. It would have happened just the same. Fault or no fault, the fault is not the cause of damage. According to the case law, Chester and Afsha of 2004, warned about the risk of surgery, should have not have taken the risk to run the operation straight away and will discuss with her family first. The Court of Appeal held that the surgeon is liable as it is his duty to inform the patient of the risk before the surgery. However, for Malaysia law, we will also apply the same test, which is the Bedford test. The case which could be applied will be the same as in the position of English law, which is the case of Chester and Hampshire. This is because under Malaysian opposition, it follows some test and judgment under English law. Hence, according to Bedford test, the defendant will only be liable in negligence if the claimant will not have suffered damage. Bedford test, defendant neglects act of omission. In this situation, Dr. Richard had failed to inform the risk of surgery to remove the blood clot in the brain, as has a 5% risk of blood clot moving to the lung, which could result in him being risked death by pulmonary embolism. By referring to decision in the case of Chester and Hampshire, Dr. Richard could be liable and he had breached his duty to warn the risk of surgery to Domio, thus not allowing Domio to make his own decision. The advice for both English law and Malaysian law will be the same. However, looking at the factors of loss of chance and causation, in fact for English law, which can refer to the case of Houston and East Berkshire Area Health Authority of 1987, where there was a 25% chance that the claimant would have made a full recovery initially and would have not had suffered a vascular necrosis. The House of Lords held that the claimant was not entitled to receive any damages as the injury was caused by the fall rather by the hospital's negligence. Hence, under the English position, Dr. Richard could argue that as the risk of blood clot moving to the lung is very low, hence there is no difference whether Domio was warned or not, as his chance of suffering the risk is the same. He will still agree on the surgery eventually, as the risk of operation is low. Thus, Dr. Richard could be held not liable.
Moving on, we need to figure out whether there is causation in law. This situation is depending on the remoteness of damage, which could be referred to the case of the wagon mount, number 1. In this case, it was held that the defendant is only liable for the reasonably foreseeable losses which was directly caused by the defendant. The court held that the consequence test was no longer applicable, but instead was replaced by the test of foreseeability. Looking at the foreseeability test, we can refer to the case of Hughes against Lord Advocate. In this case, the plaintiff took one of the lamps into the manhole and knocked the lamp into it, which caused a huge explosion. The plaintiff then suffered severe burns. It was held that the defendants were liable as the act of leaving the paraffin lamp, which will cause the plaintiff to suffer injuries, were reasonably foreseeable, and the burns that were suffered by the plaintiff in an unusual way did not prevent liabilities. In this case, Lord Pierce stated that if the damage suffered were reasonably foreseeable, the precise manner where it occurred need not have been. However, under Malaysian law, the foreseeability test was first accepted in the case of Government of Malaysia against Jumat bin Mahmud and Orbs, where it stated that the type of the damage must be reasonably foreseeable and not necessarily the exact nature of the damage. Referring to the case of Jaswant Singh against Central Electricity Board and Arnold, the court held that the damage was not too remote for if the danger of the telephone wire becoming live with electricity was foreseeable, then death or serious injuries to any person or animal coming in contact with it was also reasonably foreseeable. However, in this situation, our advice for both under English law and Malaysian law would be the same, as Dr. Richard had advised Domio to take a surgical thrombectomy to remove clots in his brain. However, the surgery contains a 5% risk of blood clot moving to the lungs, which would result in him being risked death by pulmonary embolism. By applying the law under English and Malaysian cases, since there was a 5% risk that Domio would be suffering from the surgery, the damage that was suffered by Domio after the surgery was reasonably foreseeable. Hence, Dr. Richard could be held liable. Other than that, under Malaysian law, after determining whether the damage is foreseeable, we have to see whether the defendant had taken reasonable steps to prevent the risk from happening. Here, Dr. Richard can be held liable as he had not taken reasonable steps to at least warn Domio of the risk. To conclude, Domio will be able to claim against Dr. Richard under the law of Malaysia, but not for the law of England and Wales. This is because under Malaysia law, Dr. Richard has established a duty of care towards Domio. As for breaching the duty of care, he should be liable as he had failed to warn Domio of the risk of the surgery, thus not allowing Domio to make his own decisions. Lastly, there was causation as it fulfilled the but-for test and the damage suffered was reasonably foreseeable. But under English law, Domio did not satisfy the burden of proof in establishing that Dr. Richard's actions had probably been the causative of his injury. Hence, he would not be liable. Next, in order to advise Domio of his potential claims against Dr. Newton under both the law of England and Wales and law of Malaysia, we need to determine whether there is any duty of care between Dr. Newton and Domio. According to the case of Pipping against Shepherd, the standard of care between doctors and their patients has been established. Hence, the duty of care between Dr. Newton and Domio is established. Other than that, we also need to establish whether Dr. Newton has breached his duty of care towards Domio under both English law and Malaysian law. In this situation, the Bologan Test will be applicable. Bologan Test was from the case of Bologan against Fian Hospital Management Committee, where the doctors does not give the muscle relaxant drugs to the patient who was the claimant who had mental illness, nor restrain them prior to giving them electroconvulsive therapy. It was held that the defendants were not liable as their actions were according to the approved medical treatment. Justice McNair has identified that the standard of the ordinary skilled man exercising and professing to have this special skill. Thus, it means that as long as there is a medical body who would have acted the same way as the doctor, it can be considered as no negligence. Under English law, there are circumstances to be taken into considerations. In this situation, it would be examination and diagnosis. Based on the case of Maynard against West Midland Regional Health Authority, the doctors were uncertain on whether the claimant was suffering from pulmonary tuberculosis or Hawkins disease, but advised the claimant to undergo the surgery for Hawkins disease, which carries a risk of damage to the vocal cords. Here, the House of Lords held that the consultants were not negligent as they had followed the practice that has been approved by a reasonable body of medical opinion. In contrast, the case of Polito against City and Hackney Health Authority had came out with a different approach. In this case, a 2-year-old boy suffering from croup suffered cardiac arrest and brain damage as a result that the doctor failed to attend to him when his airways were blocked. According to this case, the House of Lords also applied the Bologan Test, but it also emphasized that in the end, it was the judge and not the medical opinion that determined whether what the standard of care is required. This means that the court is able to hold that a defendant who was the doctor could not escape the liability for negligent treatment and diagnosis.
However, under Malaysian law, the first case had used the Bologan Test is the case of Chin Kiao against Government of Malaysia and another 1967, where the Privy Council quoted the Bologan Test and found that the doctor in the case was negligent. In the case of Ko Nan Seng against Nagama and others 1982, the plaintiff broke his left leg due to an accident and went to visit the doctor. The plaster was placed too tight and he complained of the pain which ignored by the doctor, and soon his leg turned gangrene and had to be amputated. In this case, the court applied the Bologan Test and held that the defendant was liable. If the plaster was applied too tightly, it will affect the blood circulation, which was aware by all doctors. Furthermore, in the case of Zul Hasmina binti Hassan Basri and others against Dr. Kupu Vulemani and others 2017, the Federal Court held that in deciding on whether there was negligence and as the issues raised were relating to diagnosis and treatment, the applicable test would be the Bologan Test, which is the medical practitioner have the final say as whether there was negligence. Regarding to the research topic, Dr. Newton had decided to advise Domio to undergo spinal fusion surgery before the CT report had been finalized, which might be the reason that caused Domio to sustain spinal cord injury during the surgery. Hence, under the English law and Malaysian law, by applying the Bologan test, if there are other medical bodies that would have acted the same way as Dr. Newton, then he can be held as not liable. But we must also take into consideration that in English law, by applying the Bologan test, would the court support the saying of other medical bodies, thus deciding whether to hold Dr. Richard liable. However, spine surgery is usually recommended only when the doctor can pinpoint the source of the pain, which is by using imaging tests such as X-rays, computerized tomography scans, and magnetic resonance imaging scans. Hence, Dr. Newton will be liable as his action is not according to the approved medical practice. Next, we must determine whether there is causation in fact. To determine the causation in fact, we need to apply but-for test, which is from the case of Koch against Kirby McLean Light Trading 1952. According to the but-for test, the defendant will only be liable in negligence if the claimant would not have suffered damage but for the defendant's negligent act or omission. However, there is an exception that was in the case of Barnett against Chelsea and Kensington Hospital Management Committee 1969. In this case, the doctor who was on duty refused to attend the three watchmen, and soon one of them died through arsenic poisoning. Here, the House of Lords acknowledged that even though this was breach of their duty, the hospital was not liable for failure to treat, as he would not have been recovered even if he is treated. However, under the Malaysian position, we can refer to the case of Swami against Matthew and others 1968. In this case, the plaintiff failed to establish that injection had caused the paralysis. It was alleged that 5 cubic centimeter acetylation had caused paralysis of the plaintiff's hand and legs. His paralysis was not caused by the injection. Both English and Malaysian cases are referring to the fact that if the fault does not happen while the damage was still ongoing, the damage caused by the defendant to the plaintiff would not be considered as negligence. In this situation, we have to establish whether Dr. Newton had done a particular fault that caused Domio to sustain limited mobility after the surgery. Also, whether the spinal cord sustained during the surgery caused by the Dr. Newton, according to the principle of the but-for test under both English law and Malaysian law. If the medical practice carried out by Dr. Newton had been practicing smoothly and correctly, he will not be found liable in this case. But if the practice had a particular fault and the fault caused damage on Domio, then Dr. Newton is found liable, as the damage to the spinal cord was sustained during the surgery. Hence, Dr. Newton should be held liable. Other than that, we also need to figure out whether there is causation in law. By that, we are alleged to apply the foreseeability test, which could be referred by the case of Hughes against Lord Advocate 1963. In this case, Lord Peirce stated that if the damage suffered is reasonably foreseeable, the precise manner in which it occurred need not have been. For Malaysian law, as mentioned in the case of in regards to the foreseeability test, we can refer to the case of Jaswant Singh against Central Electricity Board and another 1967. The court held that the damage was not too remote if the danger of the telephone wire becoming live with electricity was reasonably foreseeable. Then death or serious injury to any person or animal encountering it was also reasonably foreseeable. Hence, under both English law and Malaysian law, Dr. Newton's act of negligence during the surgery, which might have caused Domio to sustain spinal cord damage, even though the specific extent of the damage which had caused Domio to have limited mobility of his leg might not be foreseeable, the general damage caused by Dr. Newton's negligence will make Domio suffer damage is foreseeable. Dr. Newton can be found liable if the damage that was suffered by Domio is caused by Dr. Newton and also the damage suffered is foreseeable. To conclude, for Dr. Newton, under both English law and Malaysian law, he could be found liable as he had a duty of care, and if the judge does not support the statement of other medical bodies regarding the approved practice, Dr. Newton would be found liable for breaching his duty of care, and also there was causation as the damage that was suffered by Domio was because of Dr. Newton's negligence and the damage was reasonably foreseeable. In conclusion, under the law of England and Wales and law of Malaysia, Domio will be able to claim the damage from Dr. Newton. However, for Dr. Richard, Domio could claim under Malaysian law, but not under English law.